Hello, welcome to Timmy Mac Law with me, Mr. McClellan. For this video, we are going to look at the offence of battery. Now, whenever we cover an offence or indeed a defence, don't forget your concepts of liability. They are the actus reus, omissions, causation, the mens rea, transferred malice, and contemporaneity rule. They should be at the forefront of your mind whenever you're committing yourself to any sort of scenario analysis. So don't forget those concepts of liability. Just as a little bit of a reminder as well that it's probably worth watching my video on an assault before you carry on watching this video on battery, simply because the two offences often occur at the same time, and to fully understand what a battery is, it's probably necessary to fully understand what an assault is first. So therefore do watch that video on an assault before carrying on with this particular video. Just as a little bit of a recap, there will be some sort of revision on an assault because many of the things that apply to an assault do also apply to a battery. So for example, assault and battery together, they are referenced as common assault. They are separate offences, but you'll often read an assault or indeed a battery as common assault. Why is it called common assault? Because it's based on the common law, or they are based on the common law. There is no statute which defines what an assault or a battery is. The closest thing that we have is section 39 of the Criminal Justice Act 1988, but battery is merely recognised in section 39 of the Criminal Justice Act 1988, where it talks about the sentencing of a battery and indeed the sentencing of an assault. So do make sure you include that word recognised, okay? That statute merely recognises that a battery is an offence rather than defining it. In terms of the definition itself, well, we'll get to that in just a second, but just to recap, same for an assault, a battery is a summary offence. It will be heard in the magistrate's court and it will give you a sentence, should you be found guilty, of 6 months in custody, in prison in other words, or indeed a £5,000. And you can actually get both of those together, just like you can if you're found guilty of an assault. In terms of the definition of a battery, well, this comes from the case of Ireland, 1997. And if you remember, that's the case where you had the stalker who was making phone calls to the victim. From that case, and we looked at that case when we covered what an assault is, here comes the definition of a battery, and it is where the defendant intentionally or recklessly applies unlawful force upon the victim. In other words, it's where the defendant carries out an unwanted touching of the victim. Don't think of the unwanted touching as being indecent or indeed of a sexual nature. It is purely and simply unwanted physical contact, okay? But the wordy definition, if you like, the defendant intentionally or recklessly applies unlawful force upon the victim. And as ever, it's necessary to analyse the actual meaning, the practical application of that definition by unpicking some of these key words, which we're going to do for the rest of this video. So let's start off with the actus reus first, as we always should do, the physical element of a crime, by looking at the word applies, application. So, in terms of a battery, we need an act. Same with an assault, there has to be an act, unless there is a duty to act. In other words, you can carry out a battery via an omission, indeed where there is a failure to act. But you can only be found liable for a failure to act, which carries out a battery, if indeed the defendant has a duty to act. Similar to assault, that principle comes from the case of Santa Bermudez 2003, and if you remember from the assault video, that was where the defendant was being searched by a female police officer, and the defendant should have told the female police officer when asked that he had sharp objects, indeed a hypodermic needle, on his person. He set in motion a chain of events, or indeed created a dangerous situation. He therefore had a duty to act, and he didn't fulfill that duty. He didn't act by telling the police officer that he had that hypodermic needle on his person, and indeed she was pricked by it. And therefore, the defendant in that case, Santa Bermudez, was found liable for an offence. So, most of the time, a battery will be committed with an act, but just watch out for that little quirk, that it can be carried out via an omission, a failure to act, where indeed the defendant has a duty to act. Similarly, a battery most often will be carried out by a direct act, and that's where you have the defendant making direct physical contact with the victim. I go to punch someone. I'm making direct physical contact with the victim as the defendant, okay? So that's more often than not how a battery will occur. Fairly common sense stuff. However, a battery can also occur via indirect force, okay? This is obviously more rare, but indeed it can happen. So, as an example, the case of Hasted was where the defendant applied indirect force onto a third person, which allowed the offence to eventually be committed. So in this case, the defendant actually hit a woman, and the woman was carrying a baby, and the woman dropped the baby, injuring the baby, and therefore the defendant was found liable of an offence against the baby, even though the defendant argued there was no physical contact on the baby. The defendant, according to their point of view, had merely made physical contact with the woman who had dropped the baby. Anyway, the court wasn't having that argument, and therefore the defendant was found liable for an indirect battery. So there doesn't necessarily have to be direct physical contact between the defendant and the victim. Indirect contact will suffice. Other examples of that, well, these are really unusual cases. Both the case of Martin and DPP, the Department of Public Prosecutions, versus K, I'll talk about the letter K in just a second, they both involved booby traps. And indeed, the use of those booby traps led to the indirect application of force onto the victim. Why the letter K in the case of DPP versus K? Well, you should always bear this in mind. It's an anonymous defendant. It's a child defendant, and therefore they're going to retain their anonymity in this particular case. Hence just the initial of indeed probably their surname. Okay, so that's why the case is written as it is. Now in the case of Martin, real old case, 1881, really strange set of circumstances and a really unusual behaviour by the defendant here. The defendant actually walked into a theatre, a rather busy theatre, turned out the light, put an iron bar across the exit, and then shouted fire. Cue a mass panic, an understandable commotion, and people started to flee to the exit, and obviously they were injured on the iron bar which the defendant had rather strangely placed across the exit. So a really strange practical joke, if you like, obviously caused a number of injuries to various people, and indeed the defendant was found liable of an offence, even though they argued that they didn't make direct physical contact with the victims. Again, the court wasn't having that argument, and indeed the defendant was found liable for an indirect battery. With the case of DPP versus K, much more modern case, kind of equally strange, but perhaps not quite as strange as Martin. At least I can understand where the defendant was coming from in terms of trying to carry out the behaviour that they did. So in this particular case, the defendant actually took some acid from a laboratory in school, and they went to the toilet to try and test the acid on some toilet paper. The defendant, who of course was a child, then heard footsteps coming down the corridor and panicked. They therefore hid the acid in a hand dryer and then obviously left the scene, probably to go back to their lesson. Unfortunately for the defendant, a child then came along into the toilet, turned on the hand dryer which contained the acid, and it blew up essentially on their person, causing them an injury. Now, of course, there was no direct physical contact between the defendant who had put the acid in the hand dryer and indeed the victim, but it didn't matter. Indirect force was sufficient in order for the defendant to be found liable of an offence. So, doesn't often happen where it's indirect force, but it can happen, okay? So bear that in mind. Next key word, guys, in terms of the actus reus, we've got the word unlawful. So, if you are going to physically touch someone, which of course happens a lot in everyday life, then it should be with legal justification, because without legal justification, it will be considered to be unlawful, okay? And, you know, there are common situations where there is legal justification to physically touch someone, for example, the police arresting someone, and indeed we experience this in our everyday lives pretty much all the time. We may get jostled in a crowd. it's not like you can go around accusing people of committing a battery against you because, of course, you have put yourself in that position where you are likely to be jostled by a crowd, perhaps at a football match as an example. So we've got to look at what is socially acceptable when it comes to unwanted physical touching or indeed physical touching per se. Okay. Equally, self-defense. You may need to use self-defense and apply lawful force onto another, physically touch someone else in order to defend yourself. So they would have legal justifications, those situations. Just to kind of really emphasize this issue of consent though, okay? Because in our everyday lives, we make physical contact with other people. Sometimes we intend it, sometimes we expect it, and therefore, where that happens, more often than not, it's not going to lead to any offence. Otherwise, the courts will be jam-packed full of battery cases just because someone has physically contacted someone else. And indeed, that physical contact may be unwanted. You know, going into the supermarket with a shopping trolley, you may get jostled by a fellow shopper. You've just got to expect that. And indeed, this issue of consent is really useful to understand because quite often consent has to be implied consent. So, for example, if you go to a rock concert and you are standing up in amongst the crowd, you are giving implied consent to everyone in that crowd to touch you. So long as it's not indecent or of a sexual nature, that touching is perfectly lawful because that is what is expected of that particular venue. So implied consent, you give implied consent in all sorts of social situations, not least when you're walking down a corridor of a busy school and you may get knocked by other people. That's perfectly lawful because it's socially acceptable, it's socially expected. You can also give express consent. So, for example, you can say to someone, please push me. Quite an unusual thing to do, but it can happen. Please touch me on the shoulder. You are giving express consent, and therefore, were someone to push you or indeed touch you on the shoulder, that is perfectly lawful behaviour. It doesn't constitute a battery offence. However, if you look at the case of Collins versus Wilcox, it gives you an example of where the defendant's behaviour wasn't considered to be within the scope of normal behaviour or within the scope of what is socially acceptable. So in this case, the defendant was actually a police officer, and the police officer, together with a fellow police officer, had seen two women who they suspected of soliciting prostitution, okay? And therefore, the police officer, the defendant, went to challenge the eventual victim and asked for her identity because he didn't recognise the victim who they suspected of being a prostitute. Well, when the police officer challenged and approached the eventual victim, she refused to cooperate and simply walked away from the police officer. And at that point, the police officer grabbed the victim by the arm. Now, it was considered that that was not socially acceptable for a police officer to do. The police officer was not carrying out an arrest, and therefore he really had no justification for grabbing the victim by the arm. So the victim had not given express consent to that. The victim had not told the police officer, please grab my arm, and nothing like that happened. And there wasn't even implied consent. We don't give implied consent to police officers to touch us unless they are, of course, making an arrest or they are trying to protect us in some sort of way. But that wasn't the situation here. The police officer was merely trying to get the identity of the victim, and therefore the police officer was found liable for an offence. It went beyond what was socially acceptable. The victim had not consented to the unwanted touching. Moving on, let's look at the actus reus element of force. Well, force, don't think it can mean any sort of powerful force. It simply does not mean that. Minimal force will suffice, and that does include the slightest touching. So it can literally include, in theory, a tap on the shoulder, nothing more than that. So long as it is unwanted, it can constitute a battery. Case example here is Thomas 1985, and this was where a school caretaker actually tugged and indeed rubbed the hem of a schoolgirl. Now, it wasn't anything indecent, apparently. The touching, though, of the schoolgirl's skirt was considered to be a battery. So there wasn't actually direct skin-to-skin contact between the defendant, the caretaker, and the schoolgirl, but it was sufficient for a battery, although the defendant was actually found not liable of the offence, as it turned out, although the judge did make the point that touching someone's clothing is sufficient for a battery. So it does only have to be the slightest touch, and doesn't even have to be physical skin-to-skin contact. It can just be the tugging of clothing, as an example. Equally, though, in the case of Thomas, the defendant was probably not found liable because the rubbing of the girl's skirt, even though it sounds slightly unusual, it wasn't seen to be hostile touching. And if touching someone is considered to be hostile, it has some sort of malice connected with it, then it does increase the likelihood of conviction. That said, there doesn't necessarily have to be hostility when it comes to touching someone else. If the touch is considered to be unwanted, therefore it can constitute a battery. But any element of hostility will increase the likelihood of a conviction. Okay? Just to re-emphasise the point, guys, I think we've covered it already, but the force must be outside the scope of what is socially acceptable. Nice case example here relating to the case of Wilson Pringle, 1987. So in this particular case, it was two schoolboys who were messing around. It was an example of horseplay, and one of the schoolboys, the defendant, chucked the victim's bag to one side, yanked them to one side, and the victim fell over and hurt their hip. Given that there was no hostility involved in that particular situation, and also given the fact that we do really expect schoolboys to engage in this sort of horseplay, the defendant was not found liable of an offence. So in other words, tugging on a schoolboy's bag, if you are a fellow schoolboy, as a course of horseplay, messing about, was considered to be socially acceptable and therefore didn't lead to an offence. So there's the actus reus elements covered. We'll now move on to the mens rea, the mental element of a crime, and more often than not, unwanted touching will be intended. And of course, that level of mens rea will be sufficient for a battery conviction if the defendant intends the unwanted touching. And they know it's unwanted, of course. Equally, though, being reckless will suffice as the level of mens rea in order to lead to a battery conviction. Okay? So, this is based on the notion of subjective recklessness. In short, this is where the defendant knows that they are taking a risk, but decides to take that risk anyway. They're conscious of the risk of unwanted touching via their behaviour. So, 3 case examples for this. We've got the case of Venner, 1976, first of all, and this is where the defendant, with 1 or 2 friends it seems, was being really loud in the early hours of the morning. They were bashing dustbin lids and they were singing and shouting. Obviously arose suspicion of the police, and a police officer did indeed arrive at the scene to try and stop the defendant from engaging in loutish and loud behaviour. At that point, though, the defendant refused to cooperate and a police officer called for backup, and a total of 4 police officers arrived at the scene in the end. The defendant, Mr. Venner, still didn't cooperate and merely sat down, refusing to get up. Indeed, the police officer at this point was trying to arrest the defendant, but the defendant refused to get up and indeed was becoming quite violent towards the other police officers, lashing out, kicking rather furiously, and indeed the police officers were getting injured because of the defendant's lashing and kicking out. But in court, the defendant actually argued that he was not aware that those kicks would be against the police officer or would be indeed against any other person. But indeed, the prosecution managed to successfully argue that the defendant must have been aware that they were taking a risk in lashing out with their feet, and therefore it was always likely that someone could get hurt. So the argument that the defendant didn't know that their kicking out would hurt someone wasn't accepted, and their conviction was based on subjective recklessness. They knew they were taking a risk, but they decided to take that risk anyway. Next case example is the case of Savage. This involved a pint of beer whereby the defendant wanted to throw a pint of beer, the liquid itself, onto the victim. But unfortunately for the defendant, and indeed unfortunately for the victim, the pint glass slipped out of the defendant's hand, indeed causing a cut on the victim. And of course, if you're getting a pint of beer and you're going like that, or a similar sort of action, there is always the risk that the beer pint glass will slip out of your hand. And therefore, the defendant was found liable of an offence based on the fact that they were aware that they were taking a risk, but they decided to take that risk anyway in doing that motion with a pint glass. And then final case example is the case of Parmer. And this is where the defendant was playing around or handling a baby, but unfortunately the baby had quite severe injuries, indeed broken bones, because of the defendant's handling of the child, of the baby. Now, the defendant argued that they didn't intend for those broken bones to occur, but indeed, if you're handling a baby rather roughly, you must be aware that you are taking a risk that you will cause an injury or indeed some sort of unwanted touching as well. So therefore, on that basis, the defendant was found liable of an offence. So that's a complete rundown of battery. Relatively straightforward offence to deal with should you get it in a scenario, but I would just add this note of caution. Do take care when it comes to a battery and indeed an assault, because the two often happen at the same time. You go to draw back your fist, there's the assault because the victim apprehends the use of immediate unlawful force, and then you make physical contact with the victim. At this stage, I'm not talking about any sort of injury or the extent of an injury that could occur in that particular situation. We'll deal with that a little bit later on in future videos, but in simple terms, you would have the assault and then you would have the physical contact, okay? So that's normally how the offences work. But take care, because a battery can exist without an assault. And think of the situation if someone comes from behind you and hits you on the head. You may not have had the opportunity to apprehend the use of immediate and unlawful force against you. In other words, you may not have realised that any sort of physical contact was coming your way, and therefore an assault would not have been committed against you. It would just literally be the unwanted physical touching. So a battery in a situation like that can exist on its own without an assault. Rare, but it can happen, and indeed it does sometimes pop up in scenarios. So just bear that in mind. A battery can sometimes occur on its own, and indeed an assault can also occur on its own. You just draw back your fist, but you don't apply the physical contact. Hope that's useful. Thank you very much.